everyone. How are you doing? Yeah, Happy New Year. Happy New Week. How are you doing? Wherever you're watching from, hope you're good. This is Lawyers Info Hub, a platform where we teach law, we simplify law concepts into easy forms for you to understand, assimilate. We bring in people to share the legal experiences aimed at helping you become a better person, a better lawyer, a better law student. So today we're looking at something very important. We're looking at the concept of guarantor, the concept of surety, the concept of witness. These three words, many people do not understand what they mean, if they are similar, if there are differences, So when they hear these three words, sometimes they tend to not to be involved in whatever revolves around them. So today we're going to break them into pieces for you to understand, to have at least a grip of who a guarantor is, the liabilities of a guarantor, who is a surety, who can be a surety, what can a surety do, who is a witness, and all of that. So sit back, relax, and watch. If you're yet to subscribe to the channel, please do hit the subscribe button, share this video, drop in your questions here. If there's a question bothering you on this concept, drop it in on the comment section. You'll get an answer to them. So let's hit it as it is. Who is a guarantor? A guarantor is a person who takes over the liability of another. A guarantor can be called a surety. Yeah. A guarantor can be called an undertaker. A guarantor can also be called a secondary debtor. You see, in a debt situation, there is a creditor, the person who is to give out the money. There is the principal debtor, the person who is collecting the money. And there's a secondary debtor who is the guarantor, who is saying, I'm going to stand in for the principal debtor. For peradventure he doesn't pay, I pay. So a guarantor is a person who takes over the liability of another person. These days, even when you're getting a job, they say, we want a guarantor. You get a new house, we want a guarantor. You're a lot of things, even to get some contract now, they say, get us a guarantor. Because they want to be sure that peradventure there's a problem with you, uh, you know, meeting the terms. We have someone to hold on to. So when people bring guarantor forms for you to fill, when the people bring guarantee contract for you to sign, you must read in the terms, read it through, give it to your lawyer. If you cannot understand what is being written, don't just sign. You see, sometimes in court, people saying, I didn't know what I was signing. I was pressured. I was induced. I was under pressure. I didn't understand what I was signing. Yeah, so you need to know what you sign. Don't just sign documents. Don't just someone calls you, just go and sign without reading the document, understanding the words and the terms and conditions. So when you're standing as a guarantor, you must understand that you're because you're like stepping into the shoes of another person. Now, you see that once the principal debtor fails to pay up or to live up to expectation as per the contract, the guarantor what pays. Now, in the case of Chami against UBA PLC, is a 2010 case. Um, Law Pavilion Electronic Law Report 841 is a Supreme Court matter. The Supreme Court case where the liability of a guarantor was examined. Say that the liability of a guarantor becomes due and it matures immediately. The debtor or the borrower becomes unable to pay its outstanding debt. Yes, once the principal debtor cannot pay, the liability of the guarantor, that's when it kicks off. You have the case of Ebony Finance and Securities Limited against Wolo Geotechnical Services Limited and two others is the 1996 7 Nigerian Weekly Law Report, part 461, 464 at 476. Where the liability of a guarantor was also, stated and what's harmonized. So when a person enters a contract of guarantee, see, sometimes this guarantor of a thing, it doesn't come in a form again. You see people bringing in a contract for you to sign. It just say it's just a guarantor form. But by the time you go through, you see that it is a guarantee contract, a guarantee contract, contract of guarantee, or contract of suretyship, contract of undertaking, as an undertaker. So it comes in different forms and varieties. And now you say this contract, when it is executed and signed, It means it's a distinct, it is a separate contract from the principal debtors. Yes. You see, what it's trying to say is that now you have the creditor, we have the debtor, that's the principal debtors. Someone has gone to the microfinance to get a loan, for example. There's a contract between this person who is the creditor who is giving the money and the debtor who is the principal debtor who is collecting the money. Now they say, go get us a guarantor. He gets a guarantor. Now, what the court is saying is that once that guarantor has signed a contract of guarantee, the contract he has with the creditor is not different from the contract the principal debtor has with the creditor. There are now two contracts. The one contract between the principal debtor and the creditor, the second contract between the guarantor, who is the secondary debtor, and the creditor. So it's saying that once a person enters a contract of guarantee or suretyship, there's a distinct and a separate contract from the principal debtor, which is created between the guarantor and the creditor. So there are twin contracts, one between the creditor and the principal debtor, and one between the creditor and what? The guarantor. So the contract can be enforced against the guarantor directly or independently, even without joining the principal debtor. Someone has gone to the bank to get a loan and you're the guarantor. The bank can start looking for you as a guarantor, even without recourse to the person who came to borrow. That is, the downside of what a guarantor is all about, the guaranteeship contract. So when people come to you to guarantee, you can stand in a guarantor, but you must know what you're doing. It's not everybody should stand in as a guarantor for. Now, for some people, there are some restrictions why they cannot even stand as a guarantor. Maybe their workplace organization where they work, say for the period you're working for us, you're not going to stand as a guarantor for anyone. Some work people, places have such an arrangement for my moral beliefs and for maybe their bad experiences they've had in the past. They'll say, I almost died. I had issues with this person, so I'm not going to stand in for you. So these are the reasons why sometimes, and the fact that maybe they don't even know you so well. So these are some of the reasons why people do not like standing in as a guarantor. Please, before you stand in as a guarantor, read the contract, read the form, read it very well before you sign. If you're not comfortable with it, express your concerns. Don't be cajoled. It does nothing. It's a formality. Don't be cajoled to just sign in for someone as a guarantor when you don't even know who the person is, when you don't even know anything about the person, or because this person is good to you, you just sign. You don't even know anything. When there's trouble, you start saying, I was forced, I was coerced. Ignorance of the law is not an excuse. Be guided. Now, so the creditor can come against the guarantor independently without even joining the principal debtor. So you have the case of Ekerebe against a Filzioma. 2, the 1993 7 Nigerian Weekly Law Reports, Part 307, 588 and 601. That's all the cases that talks about the liability of a guarantor, who can be a guarantor, when does the liability of a guarantor arise? Once the debt becomes due and matured. Yes. No, some people have the view that it is only when the principal debtor cannot pay the debt and that the creditor has exhausted all means to get the debt paid by the principal debtor that a guarantee, you can start looking for the guarantor. These days, no, that's some school of thought. But no, the law is, once the debt, is due and unpaid, the liability of a guarantor, kicks off. So that is it for a guarantor. Just like I earlier said, is a person who stands in, takes over the liability of another. And a guarantor can also be called as can be called as a surety. Now let's look at the surety in a criminal law setting. Now, in a criminal case, once a person, is arraignment. I've talked about arraignment in this channel. Check out my videos on arraignment. The person's plea is taken. Whether the person pleads, whether I'm guilty or not, then the next thing is, if it's a bailable offense, application for bail. Now, when an application for bail is being made to the court considers it, gives you the bail terms, then most times, there's always a surety. Yes. Then court gives out a bail condition. Say, okay, the shorty, this person has to bring a shorty of so 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 so. Sometimes the court puts up a shorty of maybe 15 as a civil servant at grade level 15. Sometimes it depends on what the crime is or the offense is. They can say, okay, a shorty must have a landed property. The shorty must be someone with a blood that is related by blood with the accused. They can say it's a shorty must be a traditional ruler or someone that is in a Christian or maybe pastor. Sometimes the court specifies who a shorty for a person can be. Now, in that context, that shorty, comes in to sign in for the person, fills the necessary forms, and the courts always want to verify who the shorty is. Now, we look at what qualifies in that concept of a criminal trial, who qualifies to be a shorty. There's no special qualification, but the court will first of all understand, want to know the address of this person. That's where what calls for verification. You see, in a court, they'll say, let the prosecutor go and verify the address of the shorty. The verification before they come to the court will now they'll do a little interview for the court to understand, who are you to this person? Do you fit into the conditions I've given in the bail bond in the bill, in the book, like in the bill conditions? Now, a shorty's address must be known. It must be a person of good character. You don't just get someone that already had bad criminal record to stand in as a shorty. So in that context, the court must verify who the shorty is, must know the address, must know the character of the person. Then the person must be acceptable. Sometimes there are instances the court will say, this person is not acceptable to me. Even in the police station, when someone is to be billed, they say, get a shorty. Sometimes by the time the police profiles whoever is coming, they say, I'm not, this person cannot stand in as a shorty. Yes, sometimes there are reasons that makes the court not to even accept the person as a shorty. So in that instance, in a criminal trial or in the police, for example, you want to go and bail someone, the shorty is the person that will always stand in for this person, wherein the main accused person is no more to be found or the whereabouts is unknown. They will come and get you as a shorty. So when you are standing as a shorty for someone in a criminal trial, when you are standing in as a shorty as someone in the police station, in the police station, pardon me, in the police station, then they'll collect your details. They want to know that peradventure we don't get this person, then we're going coming after you. They want you, even by the time the forms you're signing will state it. If this person is not found, that's why sometimes we have the bail bond, which will be forfeited, or you pay the bail bond. So these are things that people sometimes don't understand. They want to just sign because it's my brother. They want to sign because it's my cousin, my in-law. But you must understand what you're doing. So when people go to sign in as shorty, they must understand, if you're going for a person of a criminal trial, you must understand what is the offense of this person. You must know, do you know this person very well? You see the concept of professional shorties, it's not something that the law, permits. No. So because it's expected that for you to stand in as a shorty for someone, you must know the person. You must know what you're doing. You don't just stand as a shorty of person because you were talked to, the person, you were paid. No, no, no. The consequences is far beyond that. So once the person cannot be found, you go in. That is why lawyers are not permitted to stand in as shorties for your clients. Very unprofessional. Don't ever stand in as a shorty to your client, no matter the situation, no matter the circumstance, no matter how well you know the person. It is unprofessional. That aside, now under this issue of shorty, we now see sometimes they say women can't stand as shorties. Women can't stand as shorties. I'm not talking as a feminist. Yes, women can't stand as shorties. There is no law known in Nigeria or that says women can't stand as shorties. It's unfounded, it's unconstitutional. There's no law that stops a woman from standing as a shorty either in the police station or in the court. It amounts to discrimination on account of sex. Yes, to deny a woman the right to stand as a shorty. That's artificial disability. That is created against women. The SCJ, that's Administration of Criminal Justice Law, yes, section 118 sub 3. Say no person shall be denied or prevented or restricted from entering into any recognizance or standing as shorty or providing any security on the ground that the person is a woman. Even though this provision, there is no provision, similar provision in the CPE and the CPC, but it is in the ACJL. A woman can stand as a shorty. There is no encumbrance. There is no thing in law that stops a woman from standing as what? A shorty. So that is an extra to the class, you know. Now, under the shorty, I want to talk about bondsman or a bonds person. Sometimes you hear the word bondsman. I'm a bondsman. These are bond person. The chief judge, the ACJL, section 138, subsection 5, makes provision that the chief judge can, you know, register and license individuals or even corporate bodies or persons to act as bond persons within that jurisdiction. So the chief of a state is empowered, you know, to register or license some certain group of people who stand as bondsmen. They are not called professional sureties. They are bondsmen. They have their bail by the courts within that jurisdiction. That a bonds person is what registered. So they are registered per jurisdiction and they will act within their jurisdiction. So when you talk about surety, you also have to talk about the bonds person or the bondsman, you know, because it's a professional institution, it's a recognized institution, a group of persons who can come into say, okay, they have their qualifications, they stand in as bonds person, and they are recognized, and they know limits of what they can do and what they cannot. They can stand in as short people. They can stand as shorties, as people, but being a bondsman, there are also consequences where you don't act, you know, or you violate the terms of your license as a bonds person is an offense.